How do I get money out of a bank account when somebody has died without going to probate? Hi, I'm Darren Findling of the Probate Pro, and we're going to cover a particular process that's incredibly valuable. The form is Scale Form PC 598. Scale for State Court Administrative Order, PC for Probate Court. And the form, as you can see from the red rectangle, is called an Affidavit of Decedent Successor for delivery of certain assets owned by decedent. I call it the affidavit to avoid probate. The beauty of this is under certain circumstances, you can use this sworn statement to gain access to a bank account or financial institution for somebody that has died without the necessity of going to probate, without the necessity of paying a filing fee to the probate court, without the necessity of getting a letter of authority, publishing, paying an inventory fee, or dealing with creditors. It avoids probate, but again, under certain circumstances. Let's walk our way through the use of this very valuable form, of which I'm happy to give to you free of charge. With all of these state court administrative order forms, it is guided by a statute. As you can see in the bottom right corner, it's MCL 700.3983. It is a Michigan statute that uses the sworn statement process under certain circumstances to gain access to an account, a financial asset of the decedent. So let's walk our way through the statute. In this particular case, the statute provides that you identify the name of the person that died, in this case, the estate of, so the estate of the individual that died. You have to provide the financial institution with a certified death certificate. So again, a death certificate, the form, and at least 28 days have had to have passed from the date of death. You identify on the form your relationship to the person that died. So under section 1, you'll see it says, I am the decedent's successor surviving A, is spouse, B, adult children, or if there is no spouse or no adult children, the other relationship. Now, of course, if there's a will, you're what's called a Blvd, so you'd identify it in the next checkbox, and if you are the fiduciary or representative who is an heir of the Blvd. So for example, one of the heirs is represented by a guardian or conservator, you'd identify their incapacity and the basis that you have standing to file this particular document. It's very important that you fill out this section correctly because not anyone can use the form. So for example, if there's a spouse and you're an adult child, the spouse has priority over the adult child. So you have to really understand the mechanics of when you have a right to access the asset based on your priority under the laws of intestacy. That means when you die without a will, or testacy if you have died with a will, or if you're a creditor and you, for example, paid the funeral bill or are owed money in some way. Let's work our way further down the form. You identify the residency of the decedent. Now, of course, you're going to identify the city and township and city or township and the state and the date of death. And then the key provision here, more than 28 days have passed since the death. And this is really important because often people are trying to gain access to a bank account to pay for a funeral or burial or cremation. This process will not be utilized to be able to do that within the 28-day window. You'd have to use an order of assignment process, which I've explained in other videos, or the full probate process. In addition, you have to certify that there is no real property included in the estate. So what does real property mean? Land, house, etc. Number 4 identifies that the decedent's estate, less liens and encumbrances, those are liens and things that are encumbered on the property, does not exceed, at the time of the creation of this document, it was $15,000. But there's an adjustment for the cost of living. And that statute, MCL 700.1210, provides for an escalating amount of money that you can use this form for. And in 2020, that amount was $24,000. So if the bank account is less than $24,000, this form can be used. Incredibly valuable for many people who die without a lot of money in a bank account and people need to gain access to it. You don't have to go to probate. You can use this form to gain access in Michigan to those assets. In addition, number 5 says that there is no probate pending, and you have to certify an application or petition for the appointment of a personal representative is not pending nor has it been granted in any jurisdiction. So you're making that assertion that there is no probate involved. In addition, that you have not asked for a petition for assignment. These are orders. The petition for assignment is a statutory process that you can use to gain access to assets. It's a different process than the affidavit process. The next section, under number 6, identifies your basis for your right to the property and the amount. So for example, you would identify the bank account or the check or the cash or the asset that you're asking to be turned over. Number 7 identifies the names, address, relationship, and percentage share under the laws of either intestacy or testacy that identify your right to receive in that share. So for example, if you're the spouse, you'd identify you're the spouse and you'd write 100% if that was what was going on. Number 8 is that a copy of the death certificate is attached. I said certified, even though it doesn't say certified on the form. In most cases, the financial institutions will not release the funds without the certified death certificate and the affidavit. Then there's a spot for you to sign, put your name, address, your contact information, and then, very importantly, the notarization. The document must be notarized. Now, there's a clause at the bottom that says notice. A false statement of an affidavit will subject you to prosecution under the penalties of perjury. And whenever you fill out any of these forms, you are subjecting yourselves to the penalties of perjury. So it is critical that you fill them out correctly and accurately, true to the best of your information, knowledge, and belief. Fill the form out, get it notarized, present it to the financial institution, and then you gotta wait. Because usually the teller at the bank, the financial institution, is not going to know what to do with the document. They're going to want to send it to their legal department for review and audit, and maybe a day or two or maybe even a week will go by, and then hopefully they'll call you up and say you can come pick up the asset, and you've done so without the need for probate. Now again, this form is used under a particular set of circumstances. It's not used in every circumstance, and it's an incredibly valuable form to use to gain access to an account of which you have the right to receive it. You have the right to inherit it. So again, make sure you've read the statute, consult with an attorney to ensure that you're filling out the form correctly, because doing so incorrectly can get you in a whole heap of trouble. We hope that this affidavit process gives you the ability to gain access to an asset and avoid probate when appropriate. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular form or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.